The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain the disclosure of medical records and mental health records in Illinois child custody cases. Let's first talk about why medical and mental health records are relevant to child custody. In determining the custody of a child, or parenting time and responsibility as it's referred to these days, a court will look towards the best interest of the child and weigh a number of factors. One of those factors is the mental and physical health of both parents. It's kind of obvious, but illnesses may impact the ability of a parent to care for the child on a full-time basis and the stability of a child's home life. And that is the case whether these are physical or mental illness. The more severe the illness, the less likely it is that that parent might be given residential responsibilities over the child, although this is only one factor among many, so this is weighed in the context of all of the other situations in the family's life. So we need really to get these records if there's custody litigation and the parents aren't coming to a negotiated settlement of their parenting time and responsibility. So let's talk about how to obtain these records. The medical records require the consent of the patient. So if the patient does consent, the party to the child custody case who the records are required from, the attorney will prepare a release and have the client sign it and deliver it to the medical provider, who will then make the records available. Unlike physical health records, mental health records also require the therapist's consent. There's things that are discussed in sessions with a therapist. The therapist might say that they don't want to have revealed. So it's not just the consent of the patient, but also of the therapist. So why would, if consent is required, why would the patient or therapist consent to the release of these records? Well, the main reason is that if the records are going to be gotten anyway through a court order, it's a lot cheaper for everybody involved to consent to the release of the records than to argue in court through attorneys and litigate over whether the records are going to be released. So a good attorney for the medical or mental health patient will be able to tell them, yeah, these are records that the court will probably require us to produce anyway. We should consent to the release of the records. Or these are records that aren't relevant to the care of your child. The other side is just trying to dig you through the mud. Let's fight about it. Let's not consent to the release of these records because the court will probably side with us. So if it's the type of record that the attorney thinks the court is going to require them to produce, it's usually better for everyone involved if the patient consents. If the patient or the therapist refuse, there's usually going to be a court hearing about it, and the right to privacy will be weighed against the best interest of the child and the relevancy of the records that are requested, the reasons for refusing to provide them, the mechanism that you use to get these records when they're not being given voluntarily is a subpoena. And then usually the party will issue a subpoena, the party requesting the records, to the third party that they're requesting the records from, and then either the other party that is the patient or the medical facility can object to the subpoena, and then the parties can have a court hearing. Usually there's briefing involved, and they can argue about it in court. Again, this is not ideal because this can cost some money and you're paying attorneys to deal with this issue. But it can be important if one side is just dredging up medical records that aren't relevant in order to make the other side look bad. And again, relevancy goes towards whether the medical or mental illness has an impact on the potential best interest of the child when you're trying to decide parenting time and responsibility. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices in several geographic locations for your convenience. If you found this helpful, we'd love it if you subscribe to us on SoundCloud or YouTube or Apple Podcasts or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.